The broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone, or good afternoon, and we'll be getting started here in about 1 minute. Okay, good afternoon, everyone, and thank you for taking the time to be with us today on our Department of Labor webinar. I am Joe Corio, Senior Vice President at URL Insurance Group, and we are delighted to have everybody with us today. First and foremost, I would like to thank everyone for the business they write through URL Insurance Group. We know you have a choice of where you do your business, and we are very thankful that you are working with URL. And we promise to do our best to earn your business, and we hope that you all had a very profitable and successful 2006, and we really hope that we were a big part of that. Okay, let's start today with the legal happenings with the DOL. I like to keep these bi-weekly updates short and sweet so we can get right to it. So what has happened in regards to the DOL since the last time we got together 2 weeks ago? There have been a few items that I want to review with you that have surfaced since then. On January 6th, Representative Joe Wilson, who is a Republican from South Carolina, introduced a bill that would delay the effective date of the fiduciary rule by up to 2 years. This is the first time that the formal submission of delaying the rule has taken place. Representative Wilson called the DOL rule one of the most costly, burdensome regulations to come from the Obama administration. He went on to say that rather than making retirement advice and financial stability more accessible for American families, the Obama administration has disrupted the client-fiduciary relationship. They have increased cost and may have limited access. These same views were echoed by Virginia Fox. She is a Republican from North Carolina who chairs the House Education and Workforce Committee. So if approved, this legislation will delay the implementation of the rule 2 years, giving Congress and President-elect Donald Trump adequate time to reevaluate the regulation. To this point, Mr. Trump has not been clear about what his position on the DOL fiduciary rule is, but a delay would be welcome, and carriers and FMOs like URL would have more time to prepare for all the complexities that the rule implementation mandates. So we'll keep our eye on this for you. In regards to the current court challenges to the rule, 4 cases are ongoing in federal district courts in 4 different states. So far, judges have ruled in favor of the DOL in 2 of these court decisions that were already handed down. Hopefully a decision will be made on the U.S. Chamber of Commerce case, which was heard back in November 17th in Dallas. This is the case that showed the most promise in striking down the rule, but we're still waiting to hear a verdict on that. I believe it's important to point out that there's a lot of talk on radio and TV and a lot of articles being written about the rule being postponed or struck down now that there's a new Congress in session and a new president that will be sworn in this Friday. While that would be nice, we're still continuing to prepare for the rule that is scheduled to be in effect on April 10th, 2017, as it is currently laid out. Here at URL, we work diligently to make sure that you have everything you need in place to allow you to write as much annuity business as you care to without any interruption after April. So we're working on your behalf, and we will keep you posted on anything that changes until then. Okay, let's talk a little bit about some new information that came from the Department of Labor. Moving on from the legal aspects, there was some other information that came out in regards to the rule since our last webinar. As you may recall, the Department of Labor originally indicated a few months ago that they would be providing 3 separate clarifications of the rule, in a question and answer format, so that the fiduciary and fiduciary investment advisors would have clear guidance to adhere to the rule. Well, that first clarification was released on October 27th of 2016, and the second release was given out last Friday, January 13th. The second release included 30 questions and answers, and the goal of that release was to provide the current workforce and retirement investors with the information they need in regards to the rule. The Employee Benefits Security Administration was quick to get the information out to the public last Friday, and they did this through sending emails to all their subscribers that they had. They say that what they wanted to make it so that the public was being informed and kept informed as to what the rule was all about. The questions in the report were related to providing investors some general information about the rule so that they know what their basic rights are under the rule, and then it went into a little more specific information as well. For instance, some questions were related to information as to whether investors would have to change investment advisors or insurance agents. There were questions in regard to whether their investment advisors can start charging them fees instead of earning commissions. There were questions about what types of information their investment advisors or agents must provide to them and why they must provide that information, that kind of thing. A large majority of the questions in the clarification that came out last Friday centered on information that we have already spoken about and that I've repeated to you many times in previous webinars, such as letting investors know that we, the agent, must act in the best interest of the client and not our own interest. Included in this report, there was a short list of questions that investors could be asking their agents or investment advisors when they meet with them. So if you would like a copy of that 16-page report, please feel free to email me. My email address is on the screen, joec@urlinsgroup.com, and I'll be glad to get you those 30 questions and that the DOL sent out last Friday. One other item that we as we get closer to the DOL rule taking effect, I think it's important to review is the implementation timelines, which were outlined in the question and answers provided by the Department of Labor last Friday. As you may recall, the DOL rule is scheduled to take effect in 2 phases. This second set of questions and answers that was announced recently clearly states that starting April 10th of 2017, a broader definition of investment advice fiduciary will take effect. Starting in April, all firms and agents are required to comply with more basic conditions of the rule, such as including acknowledgement to their clients of their fiduciary status, adhering to the best interest standards, and you have to make basic disclosures of conflict of interest. In other words, if you're an insurance-only agent, you have to have your client sign a disclosure signifying that they understand that you are an insurance-only agent and that you do not represent all products that they might be interested in. The other requirements do not go into effect until January 1 of 2018. Now, this includes the best interest contract, which we have spoken about for qualified plans. So you won't need a BIC. That won't have to be signed and submitted with the qualified application until January 1 of 18. That will give financial institutions more time to draft these contracts for your use. We're working on that now. And that's a cumbersome job. I think the instructions for the BIC agreement were like 23 pages long, so it's quite an undertaking. One last point in regards to the questions and answers that the DOL published last week. These questions and answers made it clear that it is not the financial advisor or the insurance agent's job to scour the entire industry to provide the best possible product for the client out of all the products out there, to find that one product that performs best for the client. It clearly states that the advisor will not be automatically liable if an investment recommendation does not perform quite as well as the advisor and the client would have liked. In fact, it reminds clients that in some investments they could in fact lose money. Now, this is not a reason to hold your advisor or agent liable. Of course, the products we use here at URL for the most part are fixed indexed annuities and fixed annuities, and they all guarantee principal protection from market risk. But the report did do a good job of stating a sound investment plan can still lose money. But what the rule is more concerned about is that the advisor or the agent works in the best client of their best interest of the client and not their own interest. So I was very happy to see that that was in there. For now, going forward, it's as I mentioned last webinar, there is still a lot of time left to write qualified annuity business before the rule takes effect. And this is not to say by any means that you should not act in your client's best interest. We always do that. It's just to say that doing business prior to the DOL taking effect will be much, much easier than it will be after the rule takes effect. So if you have any clients out there that you are discussing working with their qualified funds, moving them over or something like that, you might want to finalize that business before April, in other words now, rather than waiting till later, like a lot of us always tend to do. So just the last few comments in closing here today. I just wanted to mention that we hope that these bi-weekly programs are providing you with the information you need to be ready to do business under the new DOL rule. We are doing everything we possibly can to completely understand the rule and to get ready to operate in a compliant manner under the rule and to provide you with the financial institution you will need to write qualified business. Once you write qualified business starting in April, you will be required that you have a financial institution to assist you, and we hope you choose URL as the institution you partner with. Also, if you have a desire to get your securities license, we can also assist you there as well. So please feel free to contact me if you have any questions or comments in regards to the information we reviewed today, or if you'd like to discuss the possibility of getting securities licensed. Our next webinar will be 2 weeks from today, Tuesday, January 31st at 2 p.m. We hope you can tune in then, but if you can't, you can register for the webinar and you will automatically receive a recorded version of it. Also, if you have missed any of our webinars, this is the 6th one that we have done. You can review them from our website, www.urlinsurancegroup.com. And if you scroll down on the home page, on the bottom left, you'll see an area called Quick Links. You can click that on and look at, then look for a webinar archive, and you could scroll down through all the webinars that URL does. The first one we recorded on the DOL was back on November 8th, and that is on there as well as the other ones that we've done. So until next time, happy selling. Thank you once again for your business, and look forward to working with you in the future. Have a great day.